panelists on this very important topic of how listing under the criminal code of terrorist entities actually propagates Israeli terror. My link into this question is acting as counsel for the Islamic Relief Fund for the Afflicted and Needy, IRFAN-Canada, for about a decade from 2011 onwards. In the course of acting as counsel for IRFAN-Canada, it received notice of revocation of its charitable status, IRFAN being at the time, back in around 2010 and previously, a well-established Muslim charity that provided relief to humanitarian relief to war-stricken areas, including Gaza and the occupied Palestinian territory. And because of that, in that context, there were allegations for about a decade, starting under the Conservatives in about 2003, 2004, about IRFAN-Canada being a front for Hamas. Those were unsubstantiated allegations, but they circulated for a period of several years, causing the organization to go under audit by the Canada Revenue Agency. It underwent 2 audits, which it substantially defended in terms of its books and records, while delivering aid to Gaza, who, as everyone will know on this call, is even prior to the latest bombardment, was just being really devastated by the blockade, by restriction of assistance. And IRFAN-Canada was one of the few organizations that was providing relief to it. At the time when it was fighting its second audit, and this would have been in 2014, in the course of raising our arguments before the Federal Court of Appeal, IRFAN-Canada was listed as a terrorist entity. It came as a shock to us, but it also wasn't shocking in a way. It came as a shock because we were involved in a process, in an adversarial process under the Income Tax Act, to basically rehabilitate the status of a charitable entity. But in the course of that, this very entity, which only months before was giving charitable assistance, was overnight transformed into a terrorist entity. That was so surprising because leave aside the fact that we knew that part of the basis for Canada Revenue Agency's attempt to revoke the charitable status of IRFAN-Canada was secret orders and investigations by the government of Israel against IRFAN-Canada through processes which, some of us might talk a little bit more about how Israel systematically violates the rule of law and fairness in terms of how it incarcerates Palestinians and extracts information. That information then becoming the basis of an audit of a Canadian charity, which then uses the same information collected by the Canada Revenue Agency to become the basis of an RCMP investigation for the listing of this organization as a terrorist entity. So what did this mean? What were sort of some of the lessons learned by this listing? And I'm going to distinguish, what the organization IRFAN-Canada went through, as opposed to the context of what now we're dealing with, grappling with in the aftermath of Samidoun's listing, because IRFAN-Canada was a charitable organization receiving charitable donations, receiving charitable gifts from not only the Muslim community, from the Arab community, from people across Canada. And there were established lists, networks of supporters who were giving money. And the whole lifeblood of this organization was to rely on its goodwill and to be able to deliver its humanitarian assistance in the region. By virtue of that listing, overnight, all of our efforts to try to have the charitable status revoked just became effectively moot, because now the organization didn't exist. It didn't have the right to transact any kind of financial measure, to receive donations, to do anything in its own name. To elaborate a bit further on that, even in the course of our attempts subsequently to try to delist IRFAN-Canada, and we were not successful in that process, and they sort of ended prematurely, for one thing, because it is not only a criminal offense for someone to donate or give money to the organization, but there needs to be special dispensation for any reason for someone to even act on behalf of that entity and to be receiving money for that purpose. And to that end, specifically as the lawyers and the legal team for IRFAN-Canada, we sought special permission or dispensation from the Attorney General of Canada to be allowed to get money for legal fees, for legal support. We were denied that. We went to the federal court and we tried to get advance costs, because really we were blocked otherwise. Advance costs means a special request to have the government fund the challenge to the listing. The federal court denied us. And so a lot of the procedures that we used in this adversarial process to try to get IRFAN-Canada delisted were just met with roadblock after roadblock. In terms of what the listing of IRFAN-Canada meant for Muslim communities throughout Canada, and everyone who was supporting it throughout the world, was that those networks potentially became subject to, they did become subject to scrutiny at a certain level, because all of the books and records of IRFAN-Canada ended up in the hands of the RCMP. Now, as a point of fact, I did not learn of specific RCMP investigations leading to criminal charges against anyone that was affiliated with IRFAN-Canada, but that does not mean that there was not persons of interest, there were not networks that were being looked at, and the specter, and this is really, really significant here, the specter of association with IRFAN-Canada for people who were legitimately interested in supporting the humanitarian efforts, particularly in Gaza, but throughout the world. Because of that scrutiny, no one obviously donated, but they distanced themselves from that organization. And so the effect had been achieved. The financial crippling of this excellent humanitarian organization delivering aid had just been crippled overnight. So I think that part of what Shane might speak to as well from a criminal law perspective that is so odious about the listing is that there is no adversarial process whereby there's a case that the organization has to meet in order to or rather for the government to meet in order to substantiate the basis of the listing. The government can simply list, and then the onus shifts over to the listed entity to become delisted. And for so many reasons, this is offensive, because it's basically a fait accompli that there is some reasonable basis already for the minister to have listed that organization. So presumptively, one may feel or one may have the impression that there's something really legitimate there. But as I've noted, a moment ago, a lot of this, the intelligence, the information that was assembled for this, laudable charitable organization was was collected by unlawful means from Israel. There was a case in the United States known as the Holy Land Foundation case, which was a very prominent case where there was sort of a network of linkages where the predecessor to IRFAN-Canada was sort of, insinuated to be part of this network of unindicted co-conspirators. And so that team, which is not that term, which is not even cognizable in a Canadian context, just, laid suspicion on IRFAN-Canada coming from the United States based on a lot of secret intelligence coming from Israel, which we know was tainted by being obtained through unlawful means. What it came down to at the end of the day, and I think this is really significant, and I'll probably end off on this and a related point, is that the fact that humanitarian and material assistance, about approximately $13 million of the $14 million that was alleged. I would say probably closer to between 11 million dollars. We detail all of this, and if anyone wants details on this case, it's all in our factum. Was actually medical supplies. We're talking about dialysis machines. We're not talking about weapons of destruction. Beyond that, there was a double count of some information, but beyond that, for about $1 million, we're looking at support for orphans, support for underprivileged children, just truly humanitarian assistance, which, because of the fact that it was in a Hamas-controlled area, there was guilt by association that this organization was an arm, effectively, of Hamas. Now, I think the efficacy, and I would say I'm using the perverse efficacy of this tool, is that guilt by association works. That part of the basis of the listing is that the reasonable grounds to believe that this organization is acting, in concert or to advance the interests of another organization. And so we're not even really talking about the activities of the individual organization. We're literally talking about guilt by association. Now, when it comes to